Court does call the case People versus Lawrence Buckner. Who just stepped out? Pardon? Approach on this matter?
No.
On. Okay. State your name.
Lawrence is family Buckner.
All right. Go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right. What are we doing on this case?
Yeah,
Okay, hold on tight. For what begins as a straightforward procedural request quickly escalates into a court battle. Buckner's lawyer is politely requesting additional time to call witnesses. But believe me, this composure won't last long. Be alert because things are going to become messy.
received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that? No.
Your Honor, I don't object to the outbreak exam or to defense counsel's request. However, lead counsel is new in the case, is not aware of something that requires people to cover up. Earlier this week, this defendant made threats to preliminary examination. A new charge,
Sir, you need to face me.
a new charge has been authorized against this defendant.
Oh, whoa alert for a new charge, and not just any accusation that could endanger a witness. Judges don't take it lightly when a defendant reportedly threatens the very person testifying against them. That's big business in court. The court recently turned its attention from scheduling to the potential revocation of the bond. The stakes are higher.
And as a result, that new charge being authorized, we were requesting remand. So we have previously advised the defender's office.
Sheriff Grant Washington is in the office.
Your Honor.
No, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt any. You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she.
This is now very important. The claimed victim is the same individual who was the subject of a no-contact order in a prior instance. In front of the judge, breaking that would be like raising a red flag. Add that to a fresh charge in the course of an ongoing case. It's a quick route to jail.
Victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatened her with criminal charges, which is why we'd be asking for this bond.
Sir, what did you want to tell me?
Sorry.
Well, Mr. Buckner, I advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please. Like, I am not guilty. And this is what I...
Well,
okay, well, Tuesday, I had a hearing for a situation that I was accused of, right? During that hearing, it was my belief, so let me just say that, it's my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was going, and I was talking to them, and nothing out of my mouth said, I'm going to threaten that lady, I'm going to get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got a few that I support. I don't want nobody getting killed else. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it. I didn't do anything wrong. The next day I woke up, I had stalking charges. That was dismissed. That was the malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Lorraine Washington is an eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Lorraine Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had out.
Stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate and informed us that it had happened. And then she did a police report, and then we authorized the charge.
Yeah,
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
This is a twist. The present defense lawyer, Mr. Johnson, was unaware that this new charge was imminent. He claims that a separate lawyer handled the matter and that he is now unable to defend a bail revocation in the middle of the hearing without any discovery. Imagine entering a legitimate ambush. This is how it seems.
Yes, Mr. Johnson, go ahead, sir.
Yana, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Jan.
Yeah. Mr. Brown, were you there on that?
I was not. First of all, I'm not there. I was not there. Michael Daddy was. I'm not sure if this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things. And I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
All right, so as it stands now, these allegations that they have filed on charge.
Well, no, it's basically charged. It's authorized at this point. It's just, it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct? Okay.
We're just talking about the witness.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video.
All right. The judge now acts as a referee. Rather than making a snap decision, he requests the footage. Well done. He wants everyone to view the video and return with facts rather than opinions. This is the quintessential courtroom management. Don't allow chaos to overrule justice. Instead, make everything tidy and equitable.
Provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say just to the court that upon looking at the video,
If you enjoyed the video, make sure to hit the like button. If not, feel free to hit dislike. But don't forget to leave a comment below and subscribe with notifications turned on so you never miss any of my content.